Welcome to Lecture 13, which is our sequence of lectures on intellectual property. We're going to begin with just the principles of intellectual property in general, and then go into some looking at some patents and explaining to you how to look at patents and understand how intellectual property works. One thing I do want to get across is that we're having a dedicated section on intellectual property, not because innovation depends exclusively on this. It's only one factor in implementation. However, given the type of work with technology and also the way things are evolving with outsourcing manufacturing infrastructure, intellectual property becomes very important to understand and to utilize in any kind of in looking at implementation options and innovation, and therefore we'll cover it in some detail in the next lectures. In our intellectual property principles, we're going to cover some lectures that were given in this class by Stephen J. Frank, who is a attorney in intellectual property, in patent prosecution in Boston area. So first, let's talk about the different kinds of protection you can have with intellectual property, because we often think about patents, but actually intellectual property covers more than that. Patents is the main category, and we can protect machines, processes, chemical compositions, really anything. It falls into general categories. For example, in the examples we've been using in class with X-rays and printing press and strained silicon, those kinds of things, generally you protect structures, like the way things are laid out, and processes that are used to fabricate things. There's also something called a business method patent, but those are kind of coming under attack these days. But anyway, what you're trying to protect can be really anything if it falls under the patentable criterion, which we'll talk about later. One thing that's important to realize, and this I think especially for engineers, is independent development, which means that you could be developing something while someone else strikes up a patent, is no defense. This is really important. So let's suppose that I'm secretly working in my basement for 10 years and someone else has been doing exactly the same thing. In fact, they started a little bit earlier, and now they've been patenting along the way. I'm ready to release product, and I say, well, I was developing it almost the entire time, and it turns out that this kind of parallel development does not matter. In fact, with the new rules that just came out, I'll show you that some of these slides have been changed recently. These slides are being put together in the end of March 2013, and in March 2013 the rules for first to invent have changed. It's now first to file, which means that independent development before filing really doesn't matter at all. In addition to patents, there's copyright, because some things don't quite fall under the patentable regime. There could be something unique, but it might not be something that can be defined by a very inventive structure or process. One type of something like that is probably the thing you're most familiar with, is if I write a play. If I write a play, it could be inventive in the sense that it's brand new and everything, but I can't patent it, so copyright was created to protect things like that, books, and cleverly by people that didn't have any protection in software in the early days, because software was really a new thing. They used the copyright. Sometimes they used, like Bill Gates, for example, used copyright to protect his early software. The copyright is generally not as strong has patents. Again, it's really narrow by definition because it's like whatever text you write on the page. And unlike patents, there's no kind of broader capability to protect a certain area. And because of that, independent development is harder to block. So, for example, this came up in software even because you could have software code that was slightly different and it produced the same result. Doesn't that mean that the copyright is being violated? And the answer in a strict sense is no. And so that's why there were these famous famous litigation cases about Windows and Apple and Microsoft and things like that because they tried to apply this look and feel. They tried to really establish a new criterion for copyright, which was that, strictly speaking, it's not just the letters on the page, but if the letters on the page produce some sort of feeling or look that's the same, that the look could be copyrighted. And in fact, those generally did not last. And so that's what's meant by having a narrowly applied, and it's hard to exclude independent development. Trade secrets are growing in importance because, as I said in the introduction, in a world where different pieces can be outsourced, and imagine if you have the one key piece. Yes, you could patent it, but once everyone knows about it, unless you're ready to protect against infringement, it could be a rather expensive process to run around the world for everybody that takes that one step that you have that's innovative. And 95% of the rest of the process is known. So unless you really have a huge war chest, it's an example where you might want to say, can I contain a trade secret that is not tell anybody and protect it in my own company? The good news about this is that courts kind of side with that if you take the best steps. So courts help those who help themselves. If you show that you maintain secrecy, and one of your employees leaves and actually tells someone else, and it's fairly straightforward, let's say it's kind of a proven case, then they'll tend to side with you. So, the problem, of course, is actually proving that that person left with that information. That's a different story. But timelines and when things were released and all that sort of thing can be used to try to imply that they left with the trade secret. Of course, the most famous case for trade secret is the Coca-Cola formula. If there's an advance that is known, and someone's willing to apply enough dollars, independent development, of course, can be used around trade secrets. So independently, if I develop the Coke formula by sheer hard work, it's okay. I can do so. And there's many colas that have come close, and there's nothing Coke can do about these close copycats from doing their thing. Another thing, of course, is to use all sorts of characterization equipment and things like that to figure out the components of Coke. Not so easy, but you can find the signature Coke. For example, you might stick it in an FTIR, far transmission infrared spectrometer, and you get signatures, and then you can tell when you're getting close by mixing up various compounds and looking at what some of the lines in the spectrum might refer to. You could probably kind of zero in over time. And anyway, this type of thing is the problem with trade secrets, that even if the employee doesn't give it to the other person can just fund to get around it. And so the trade secret is susceptible to one of the things about innovation which we have not talked about yet, which is once the early fundamental innovation part is showing some progress, it's amazing the number of people that then believe and apply resources somewhere in the middle towards the end of the process. So what that means is that confidence is actually lacking in this world of innovation. And once confidence is gained by seeing a product out there, and once people know it can exist, copycats, especially if the barrier is low, will just apply money to figure it out. In a good, so confidence is what's given by, there's first of all lack of confidence when early fundamental innovation is needed, but then as soon as product comes out, great confidence is created that, oh, this is possible, and then they can apply resources, because in most organizations, once some things exist, then you can gather resources if it's a critical thing. And a good example of this was tablet computers and the kind of screens used in the iPhone. These kinds of things, really couldn't be patented because they existed before, but they hadn't become kind of used and wanted in a particular way. The minute that it came out, if you had trade secrets around certain things, it wouldn't matter because people know basically how to do 90% of it. They invest to get the other 10%, and then they're off and running. So that's the problem with trade secrets. Most of our lecture is going to be on patents because it's the strongest form of protection, and kind of most of the time the relevant one to most innovators. So a patent is a very special thing. It's actually a property right given by the government. So this is why it's actually stronger than contract law, and we don't really specifically say that here, but I'm going to put contract law here. So contract law is when you have two companies, business to business, and they form an agreement, right? Now, when this is violated, these two businesses could end up in court, and the court decides, what happens. And it's pretty much just based on what the agreement says and whether somebody violated this. The amazing thing about a patent is the government at the federal level, say in the United States, grants you essentially a monopoly on that piece of technology for a while. So this is by far stronger than this, because another business can take you to court, and it's really your word against their word. When you have the federal system having said that you deserve this monopoly, it's a lot bigger barrier to actually knock that down, because you're telling the government itself that they shouldn't have given that monopoly. So it's you against the government, essentially, instead of you against another business. So it's actually quite powerful, and the strongest intellectual property that you can get. So this monopoly that the government grants you allows you to prevent others from essentially using the invention, and use is typically framed in manufacture, sale of, use of, anybody that's involved in I would say, commercial flow of your invention. And the reason I kind of say commercial flow is a very interesting situation where we go back to our supply chain. So remember how you might have materials feeding into some sort of device, feeding into all this thing all the way up the food chain, and then you have Google at the top. Now, the argument gets harder and harder the further you're away, but suppose that I have intellectual property, a patent on some sort of new material that allows devices to be made better, which plug into boxes, which allow the internet to do better, and therefore Google benefits. It'd be very difficult to do it this way, but in principle, there's nothing stopping you from going to Google and saying, you're infringing because Google, you're using that material in the chips which are way below. Now, that's a very difficult thing because there's a long chain to show that that's the case, but also um, there's practical constraints in that, which is you're waiting for this thing to go up and then get that person when they're finally benefiting from it. And there's rules like if you haven't pursued you haven't pursued intellectual property and try to defend your patent after some period of time, then you could lose rights to it. But the point here is that you do not have to collect the royalty or the protection at the point where the thing is physically attached, the patent is physically attached to that part of the supply chain. So, for example, in the strained silicon case, we had developed intellectual property all the way up, and we would have, in fact, taken that entire pyramid if we didn't. Eventually, Intel, the way it works is they just licensed all of Amberwood's intellectual property. But one of the reasons why, if you make a pyramid up through the entire supply chain, then in our case, we ask for royalties on the integrated circuit, right? And we had pieces here, and everywhere like that. So the bottom line is you can really just stop anybody anywhere from participating in anything to do with your invention, although the further you get away from the source, that's kind of the most obvious use of your intellectual property, the harder it is to win. A lot of people ask about countries, so if somebody's making something, let's say in Taiwan, and then I have a U.S. patent, it turns out that I can prevent this company in Taiwan from shipping in here and selling here. So if I hold the patent in the U.S. on a particular thing, even if I don't hold it over here, the way to think about it is when the thing enters the country, it automatically becomes under this patent, where if they sold it to another person in Taiwan and I didn't have a patent on Taiwan, that could be perfectly fine depending on what I choose to do. I could do a variety of things, but in general, if I only had the U.S. patent, I really couldn't stop the U.S. Taiwan person from selling to another Taiwan company. And this is what I meant by extending the national border here. So you can prevent somebody from making it within the U.S. if I have a U.S. patent, or I can make, even if I don't have patents outside the U.S., I can stop it there. And that's why if you're really under a lot of pressure to not, let's suppose that your company's really low on cash flow, and you have to fire employees, and you really don't want to because you got to keep your business going. Then you might choose to only have a U.S. patent instead of patenting both countries. And the reason is that if the U.S. is the largest market, then at the end, the default might be at least having U.S. patents. So if you have at least U.S., it's one of the largest markets in the world, and you can at least protect that market. Patent lasts 20 years from the filing, and enforceable rights, what Steve has written here, is the key term, meaning that you can't use laws of the land to stop somebody and execute your rights holding a patent until the patent actually issues. And there's a long delay from filing to the actual issuing of the patent. Now, it does not mean that you can't negotiate a license agreement during the time before the patent actually issues. And if someone is interested in the broad technology application and they're kind of wanting to license several patents, They can look at the title, you can show them pictures and just say, you know, it's not out yet, I don't want you to see it, but it's possible to license that patent or license that patent in a bundle even though it's not finally done. Of course, if the specifics about the claims matter, then you have to wait until it's issued, and you wouldn't be able to get the license agreement done because the other company clearly be waiting for, you know, some important thing to see. Oh, does he have that coverage or whatever? But many times, that kind of precision is not necessary, and you could license it at an earlier stage, even though it's not out. So let's stop there, and then next time we'll talk about the process of getting a patent.